Into all of this with our legal panel now. Bill Brennan is a criminal defense attorney who represented Trump during his second impeachment trial. And Randy Barnett is a constitutional law professor at Georgetown University. Gentlemen, and welcome. Thanks for coming on. Of course, he's also the author of Life for Liberty, The Making of an American Originalist. It hits bookshelves tomorrow. Great to have both of you here. So if Trump is immune for official acts, then so is President Biden. But realistically, how far can a president push their powers? Our commander-in-chief here, Randy.
Well, I think the most important thing to come out of today is that the Supreme Court is trying to put a stop to the lawfare that is threatening to completely bring down our form of government. We've witnessed for the last several years Democrats in Congress and now a Democratic administration attempting to prosecute their political opponents. And I believe that if this court had come out any differently than it did, and Donald Trump had won the next election, there's every reason to believe that he would have prosecuted Joe Biden for any number of crimes. The Supreme Court has done what it could to put a stop to that downward spiral. Today's decision is momentous for ending the use of lawfare, or at least limiting the use of lawfare that has been rampant over the last 4 years, in an unprecedented way, I should say.
Bill, as we've been reporting, lower courts now must determine which acts are official, what's unofficial. How long do you expect that process to play out? Understandably, many are predicting it'll be past the election.
Well, Hannah, with the case that we're talking about with Judge Chutkan, it's going to be remanded for further fact-finding. And the interesting question there is, if it's a question of law, what's official, what's unofficial, what's a rebuttable presumption, Judge Chutkan can figure that out. But there's a possibility it would have to go to the fact finder, which is the jury, similar to in a criminal case when there's two predicate acts needed to prove RICO, and the jury must find beyond a reasonable doubt whether these were proven or not. So it's really quite uncertain still where we're headed. What is certain is that it'll be remanded to the lower court, and the time alone will benefit the former president, because nothing will happen before the election. But one of the most interesting parts of this decision, in my opinion, is you could really take this, if you were on his legal team, and just do a shotgun approach and apply it to all the cases. You could certainly go, if you read this in context with Fisher that came down on Friday, the Jack Smith case is 4 counts. 2 obstruction, which were weakened by Fisher because Fisher says there has to be a documentary nexus. And then the 2 conspiracy to commit fraud in the U.S. and on voters. Now, that's been somewhat challenged by the immunity. So that case is kind of on 6 cylinders now. You could make the argument that part of the Judge Merchan New York State Supreme Court case involved dealings while he was president with Hope Hicks and the like. That could be challenged. You could certainly make the argument in Georgia that as president, when he called the Secretary of State, that's official. So it really is going to open a can of worms for the pending litigation in this case. But I agree with Randy. We shouldn't view this as a pro-Trump, anti-Trump, pro-Biden, anti-Biden case. As Justice Gorsuch said, this is a case they've written for the ages. When we're all gone, this case will still be referenced.
I want to stick with the lower court now, Randy. Actions that the court will look at January 6th will include Trump's conversation with the Vice President, Mike Pence, his public comments that led up to that day. So how will the court make this determination moving forward?
Well, the Supreme Court has given instructions and basically said that when the president was discussing what the legal course of action of the Department of Justice was going to be with the Attorney General, that was privileged, and he had immunity for that act. When it came to the vice president, they thought that is something that needed to be decided depending on whether he was discussing with the vice president that which was within his official capacity or whether he was discussing something else. I do think that the other concession that was made by Trump's lawyer during oral argument, which the court referenced, and that is that there are quite a number of private acts that the president has been accused of doing, like, for example, communicating with governors about calling legislatures into special session. And so both the government, I just want to emphasize, the U.S. government said that certain acts were privileged, including president's core powers like the war-making power. And the Trump attorney in oral argument said that certain actions of which the President Trump was accused of were, in fact, private acts. I do suspect there's going to be private acts that survive the scrutiny of a lower court when it's on remand.
Thanks so much for watching. Go to joinnn.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.